We're following a big update in the case of the former D1 cheerleader accused of giving birth to a baby, then disposing of his body in the closet of her off-campus apartment. Prosecutors seem to be taking a major step forward in building their case as they're now targeting a specific location with a new subpoena. What that could mean for the charges that Laken Snelling is facing. Plus, what she has been up to since she was put on home monitoring nearly 2 months ago. We're on the case presented by Law&Crime. I'm Stewart. Hey guys, real quick before we start this episode of On the Case, I want to talk about our partner and sponsor, Morgan & Morgan, America's largest personal injury law firm, a firm with more than 1,000 attorneys who have recovered $25 billion from more than 500,000 clients. In the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. In Pennsylvania, another client was awarded $26 million. That's 40 times the insurer's offer. Morgan & Morgan makes it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/OTC. You can also click the link below or scan the QR code on your screen. The case of Laken Snelling raises some serious questions. Are we talking about a young girl who allegedly just made an incredibly terrible error in judgment after giving birth? Or are we talking about something more than that? Is this the case of a girl who could face charges for murder? Now, at the time of this recording, we're not talking about a murder case. Laken Snelling is accused of abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. She's pleaded not guilty to those charges. Now, there are some pieces of evidence that opens the door for potentially her to face more serious charges, especially with the new subpoena that prosecutors just submitted, and we'll break that down in just a moment. But to understand where we are in this case and where it's going next, we have to break down its shocking beginning. So I want you to come with me back to August 27th of this year in Lexington, Kentucky, of course, the home of the University of Kentucky and where Laken Snelling once went to school. She was a member of the University of Kentucky Wildcats stunt cheerleading team. Big SEC school. I mean, this is a big deal. But she's no longer a student at UK because she withdrew after what police say went down in her off-campus apartment on the 27th. This is a video of the Kentucky Wildcats competing per Flow Cheer on YouTube. This video was from April of 2025, meaning that if she gave birth to a baby who was full term in August, like police say, she was very much pregnant at the time this video was taken. Now, on August 27th, Lexington police say they were called to Laken Snelling's home for a report of an unresponsive infant. That child, a baby boy, was pronounced dead on scene. Now, they say that the baby was found in a closet. An arrest citation says that the infant was wrapped in a towel inside of a black trash bag. The citation reportedly says that Snelling was read her rights and she allegedly admitted to giving birth to this baby. Then, she allegedly said that she concealed the birth by cleaning evidence and putting all the cleaning items inside of a black trash bag along with the body of that infant who was wrapped in a towel. Now, newly released court documents to the Kentucky Kernel, which is the student newspaper at UK, reveal that Snelling allegedly told police that she gave birth around 4 o'clock in the morning, and then she told officers that she did not think the baby was breathing or alive. She also said that she was awake for about a half hour, then she fell asleep on top of the baby, and when she woke up, that baby had turned blue and purple. She reportedly said that she didn't think that the baby was alive. She then said that she wrapped the baby like a burrito, then laid next to it in a moment of comfort. Now, this is all per the court documents that the student newspaper at the University of Kentucky had been able to get. Now, it is interesting how that story compares with what Laken Snelling reportedly told doctors. When Snelling woke up for class, she then allegedly wrapped the baby in a towel, then put the baby in a trash bag, and then placed that bag in the closet. She also reportedly cleaned up the blood in her room with paper towels, and she put the placenta in a Ziploc bag. Now, even though she just went through this major medical event and her son was dead, Snelling reportedly left the house to go to her class. But she says she actually didn't go into class. She instead sat in her car, and the court documents say she actually ordered McDonald's through the McDonald's app. Now, while all of this was happening, there appears to have been multiple roommates in her home. And around the time that Snelling reportedly said that she gave birth, one of her roommates texted a Snapchat group that they thought they heard something fall, and another roommate said that they thought that they had heard noises for roughly an hour from Snelling's room. Now, after Snelling left the home for class, her roommates then go into her room, and it appears she never told her roommates that she was pregnant, but they were somewhat suspicious. Now, when they entered the room, they allegedly found a blood-soaked towel and a plastic bag containing evidence of childbirth. They also found the baby, and that's when they called the police. Snelling eventually went to the hospital, and that's where this new subpoena comes in that I'll talk about in just a moment. It is at the hospital, UK Medical Center, where she allegedly told doctors that the baby displayed, quote, a little bit of fetal movement, and he made a, quote, whimper, and she, quote, guessed the baby was alive. So very different from what we're seeing her allegedly tell police at the home per those documents that the student newspaper was able to get. Now, that statement, it's going to be huge in how this case moves forward. Snelling's digital footprint may also be some key evidence as this case progresses, because it does appear that police have images of Snelling during labor that she allegedly deleted. Police said in a request for a search warrant for her social media accounts that they could, quote, contain current or deleted information that relates to Miss Snelling's pregnancy, to the birth of the full-term baby, and ultimately its potential demise. Now, publicly, Snelling appeared to be very active on social media up until roughly the spring, when she stopped posting pictures of herself, at least from what we can see. And another shocking part of this is it appears that she did present herself as someone who had aspirations to one day be a mom. This is the last post that she had on TikTok. It is from June, so roughly 2 months, maybe 3 months until she gave birth to that baby. And it is a picture with emojis that describe her. In the bottom left, you can see there is one that says goals, and it shows an emoji of a mom with a child. Now, another big question is who the father is of the boy that Snelling allegedly gave birth to inside her off-campus apartment. We know that there is an ex-boyfriend who submitted DNA to police, and we also know that Snelling was reportedly in a relationship with another man in more recent months around the time of birth. Now, it is unclear what their relationship status was at the time that she gave birth and what their relationship status is now. Other big questions in this case could be answered with this new subpoena that was put in by prosecutors just this month. According to WKYT-TV, prosecutors issued a subpoena to UK Medical Center. So that is the hospital that Laken Snelling went to, where she said that the baby perhaps was breathing when he was born. Now, the subpoena, which is dated December 9th, it demands all of Snelling's medical records going all the way back to August 2024 to now. August 2024, roughly a year before she gave birth. Now, the hospital has until January 20th to provide those documents. As this case moves forward, Snelling is not in jail. Her bond was set at $100,000, and she was able to post that. Snelling is facing 3 charges. It's abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant, and she has pleaded not guilty to those charges. Now, the new information in this case also is that the conditions of bond for Snelling, they have been changed in recent months. Snelling must now wear an electronic monitoring device while she is on house arrest. She is reportedly staying at a family home in her hometown of Tennessee. She also can only be on house arrest at one location, opposed to splitting time between her mom's house and her dad's house. She is staying at her dad's home, which is in Tennessee. Now, it is unclear what prompted that change in bond conditions. It came down at the end of October. But again, right now, Snelling's case is awaiting a potential indictment from a grand jury, which will decide officially what charges Snelling will face. And that potentially could mean perhaps murder. It perhaps could mean manslaughter is added to the charges that Laken Snelling is facing if a grand jury decides that there's evidence to support that. But again, this subpoena, which is due to be finished by January 20th from the hospital for her medical records, that could be a massive piece of evidence and information that the grand jury could look at. Joining us to talk a little bit more about this case and where it could go from here is prosecutor and former Deputy Attorney General for the state of Ohio, Mark Weaver. It's always great to have you on Law and Crime. I know we've talked about Laken Snelling and this case before over the last couple of months. What does the subpoena to the medical center tell you about where we are in this investigation?
This tells me prosecutors are trying to find enough evidence to make a manslaughter charge. Right now they have these lower level charges: abuse of a corpse, concealing a pregnancy, maybe tampering with evidence. Those are low level. I think two are low-level felonies and one is a misdemeanor. In order for them to bring any flavor of a manslaughter charge, there's several different ways to bring manslaughter depending on the intent. They need to know whether this baby was alive and whether Laken knew this baby was alive. We have some evidence already. She told some people at the hospital that she heard some sounds coming from the baby, some whimpering, I think is what she said. She noticed the color changing in the baby. That suggests the baby was alive. So you can see they are trying to make the case to be able to advance this to a more serious felony.
Why manslaughter? If this baby was born alive and then the baby ends up dying and she doesn't end up calling anybody, she ends up, she says that she passed out, but then she was going to go to class, took her some time to go to the hospital. Why manslaughter instead of murder?
Murder is hard to prove because you have to prove intent, at least, and that's the way it works in this state. The jurors are already going to feel some small amount of sympathy for this young woman. Of all the people who could be called a murderer out there, she is lower on the anger scale, if you will. People are a lot more angry at somebody who lies in wait and plans a terrible murder and then causes great pain. So prosecutors have to worry about whether or not a jury would accept a murder charge, or whether they would think, even if you met the elements, whether that's too much for what is, by all accounts, a tragic situation. That's why the law allows for lower levels of what people would call murder, but this Kentucky calls manslaughter, and it depends on your state of mind. Legal term mens rea. Was this intentional? Was this done in the heat of passion? Was this reckless? Was this negligent? In cases like this where a baby's born and then dies because the mother either left it alive or purposely killed it, often we see that the lowest level, I think it's a Class D level felony in Kentucky, which would be, some places would call it a negligent homicide or manslaughter.
When it comes to that intent part of it, and if prosecutors, and a lot of this is through media reporting, and we'll see what actually happens if and when she's indicted by a grand jury, but if it is she was hiding this pregnancy, she didn't want people to know that she was pregnant, does that factor at all into intent, where then you have this child who ends up dead if it's proven that the baby was born alive and that she covers it up? Is there any intent in there that could go from that murder to manslaughter charge, just based off the fact that it appears, allegedly, that she didn't want people to know that she was pregnant?
Yeah, it's all going to be relevant evidence, whatever she knew about how early she realized she was pregnant and what she did to keep it from people. This all suggests that she's trying, consciousness of guilt, trying to avoid being held responsible for it. It's certainly going to anger a jury, and an angry jury will look for a way to make a case. But remember, the burden falls completely on the prosecution. They must prove each and every element of the crimes they charge beyond a reasonable doubt to a unanimous jury. And as a result, they're trying to gather more evidence. Everybody wants to know, was this baby alive, and what did Laken know before this happened? She can't be made to testify. We have the Fifth Amendment, so she can't be required to testify, but the statements she's made so far can be used against her.
When it comes to this subpoena, prosecutors are reportedly, they want all the records going back to August 2024. This baby was born late August 2025. What do you make of that timeline? I mean, clearly, 9 months for a full-term pregnancy, but what do you just make of them going back that far to try and get her medical records?
They want to tell the jury a story about what happened. They want to be able to say how soon she knew she was pregnant, maybe what doctors told her she should be doing to make sure she has a healthy baby, whether she asks questions about the pregnancy and giving birth at home. We know that there's some evidence that she had some Google searches that suggested that she might be thinking of concealing the pregnancy or doing other things. So jurors, in order to return any kind of a verdict on a serious felony, they're going to really want the best, strongest evidence possible. And you can see the prosecutors trying to build that case right now.
When it comes to a subpoena, because in a lot of cases you'll have, investigators, they get a search warrant to go into a house and, be able, to try and gather evidence that way. For prosecutors, what goes into actually getting a subpoena?
Well, as you mentioned, you can do a search warrant, which requires a signature by a magistrate or a judge and a show of probable cause. But a subpoena is different. When we know we're going to trial, we can send either a subpoena that you must show up or what's called a subpoena ducis tecum, which means you must bring evidence or records with you. This is likely the latter, although they may want somebody to authenticate the records at trial. So either side, defense or prosecution, can send a third party like a hospital a subpoena saying you're going to be called into this case and you need to bring evidence with you. And so it's rather common in all litigation to issue subpoenas. Now, the prosecutor has a special kind of a subpoena called a grand jury subpoena when the grand jury is investigating a case, which says you better come and talk to the grand jury or you better bring records with you to show the grand jury because they are investigating a crime.
How difficult is it typically to get medical records from a hospital like what prosecutors are trying to do here?
Believe it or not, most hospitals are accustomed to this, and so they'll have an attorney or somebody in their administrative office who deals with these subpoenas. Now, there is a procedure where they could go to court and seek to quash the subpoena, that is to have a judge say that the record should not be provided. I'd be surprised if that were successful if they were to do that. If the records the hospital has can prove that a crime occurred, then it ought to come into the trial. Now, there might be some arguments about privilege, and perhaps defense counsel will try to raise that. But I think whatever they have will come in front of the grand jury, and it will help the grand jury decide whether a more serious felony should be brought.
What happens then once we get to that grand jury stage? That's sometimes for us in the public, we don't see that. What happens, behind the closed doors of a grand jury. Once prosecutors get the documents related to Laken Snelling, her health, her medical records, as well as everything else that they've collected over the past couple of months that this has been going on, what will happen in front of that grand jury that could lead them to something like a manslaughter charge?
I spent a lot of time in front of grand juries as a prosecutor, and I've had some that are very quiet and they just listen to what we say and then they vote. We have others who are really involved and want to know details and encourage us to go out and get more evidence. Now, grand jury is secret by law, so we don't know what kind this grand jury is, but many grand jurors want to see much more evidence than is required. The prosecutor only needs to present enough evidence that proves that there's probable cause to exist that a crime occurred. But sometimes grand juries want more. I wouldn't be surprised if that's happening here.
And when it comes to eventually, if and when this goes to trial, and we were talking about how the defense really may try to present her as a sympathetic figure. Maybe there's some witnesses that could come in to talk about how she was this member of the cheerleading team. She was a good person. Maybe her family will come through, and testify to her character. As a prosecutor, and you're trying to prove, let's just say it goes to manslaughter, how do you counter that where if the defense does a good job of presenting her as a person that a juror might be sympathetic to?
The jury instructions will usually require jurors to set aside issues of emotion and focus on the evidence. Now, during jury selection, which is called voir dire, we can inquire with potential jurors about whether they're able to do that, and we can note which ones might be better than others to do that. Then during the closing argument or the rebuttal argument for the prosecution, because the prosecution gets to go twice, closing argument for the prosecution, closing argument for the defense, and then a rebuttal argument from the prosecution. During that time, you can remind jurors of those instructions. Remind them that they are required by law to set aside issues of emotion and to really decide this on the facts. They're also required to set aside punishment and know that the judge decides punishment. But I imagine in the course of history, there have been a lot of juries that sat back in the jury room and said, I'll be darned if I'm going to vote to send a young woman like this to prison, even though that's not their choice to make. It's always the judge's choice to make.
It was late August that all of this took place. So it would have been just the start of the school year. It's been several months. We're a couple days now before Christmas. And here are prosecutors requesting medical records. I know as a member of the media, we think things are, that they happen very quickly in the span of like a TV show where it's 1 hour. I know that that's not reality. But what do you make of the timeline thus far of how this is going?
People should remember that every prosecutor's office, including the one where I work at, where I'm a part-time prosecutor, has dozens or hundreds of active cases. In the biggest cities, there's thousands of active cases, all being handled by usually a short-staffed group of investigators and assistant prosecutors. And so they're trying to juggle several things at once. Now, this is an important case. It's much more important than a burglary or an arson of an unoccupied building or something like that. But these things do take time. And you have to schedule in your grand jury for that time. And the grand jury, as I mentioned earlier, might want you to come back with more evidence. So all sorts of things could have happened in the intervening months since the death of this child was first discovered.
How much time do prosecutors have in a case like this to get to a grand jury indictment and get things moving, if she's going to be charged with something more than what she already is?
I don't practice in Kentucky, but every state has statutes of limitation, and I don't think any state puts a statute of limitation on murder. It's the lesser crimes that have statute of limitations, typically a period of years. In Ohio, for example, where I prosecute felonies, most of them at least have a 6-year statute of limitation. So it's a period of years, not months, and that's the speedy trial. Now, on the charges that's the statute of limitations. With respect to speedy trial, she is required to be brought to trial on the charges that have already been filed within whatever Kentucky's speedy trial statute is. So statute of limitations says when charges can be brought. Speedy trial is once charges have been brought, how soon must we go to trial?
For the prosecutors on this case, if and when this goes to trial, it seems like in the statements that she made to police, it was far more vague than the statements that she made reportedly to doctors, where the doctor's statement was that she heard the whimper. And then that opened the door to believe that this baby was alive when it was born. It doesn't seem like, according to what we've read thus far, that that's what she told police. What do you make of the difference there in her, from what we can tell, the difference in her stories around the time that all this happened?
My experience in and around law enforcement is people act differently when they think they're being interrogated by police. That's when it dawns on them, if you will. They realize, wow, everything I said can and will be used against me in court of law. Whether or not you get the Miranda instruction or not, people know from television and movies when you're in an interview room or when police are talking to you, and if they've got a body cam on, if they're writing notes, any of those things, any of those indicators make somebody go, gulp, this is all potentially evidence that can be used against me. We typically don't feel that way when we're talking to medical personnel. We typically are explaining something in hopes that that person can help us. And statements made during that medical procedure or the medical interview by the doctor can come in when it ordinarily wouldn't under the hearsay rule. So statements this defendant made, Laken made, can be brought in because she's the defendant. But if it were somebody else talking to a doctor, that could also come in if it's being made during a medical interview.
Right now, she's out on bond. She posted, I believe it was a $100,000 bond, and she is currently living with, I believe it's her dad in Tennessee, and she's on electronic monitoring there. If she were to be charged with something like manslaughter, what impact could that have on the conditions of her bond?
Yeah, for a more serious felony, the judge will first of all have to re-arraign or a new arraignment on these new charges. It's kind of a re-arraignment because she's already been arraigned once on the other charges. And the condition of bond will almost certainly change. The prosecutor will ask for a higher bond. I'd be surprised if they asked for no bond. This is not a case where she's a danger to the community. The danger she posed was to her child. Nobody thinks she's a murderer who's going to go on a murdering spree. So, but certainly the judge would raise the level of bond because the stakes have been raised, right? The higher the level of the crime, the more likely somebody might be to leave the jurisdiction to flee responsibility for that more significant crime.
And we'll see what happens next. UK Medical Center has until January 20th to return the subpoena with the documents for Laken Snelling, her medical records going back to August 2024. We'll see what happens next. Mark Weaver, prosecutor, former Deputy Attorney General for the state of Ohio. Thank you as always for being with us on Law and Crime. We appreciate it.
Always good to be with you, Chris. Thank you.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.